Welcome, everyone. I'm Peter Kandinov, police officer with employee assistance. Um, Please mute yourself. We will have question and answers at the end. If you have any questions, general questions, please post them in the chat box on the bottom of your screen, and I will ask those questions on your behalf. Um, Also, stay till the end because at the end of the presentation, I'm going to announce a couple of news about what club has, uh, what's going on with the club and some latest developments with the club, some great news. So without further delay, I want to introduce our two guest speakers for this month. Thank you so much, David and Erica. And if you don't mind, please introduce yourself and the floor is yours.
Well, thank you, Peter, for that warm welcome. Like Peter said, my name is Erica Shapiro, and I'm a partner at Gemelli Gross Shapiro and Marino, as you can see here on the screen. I'm here along with David Gross, my colleague and partner, and we're both going to talk to you today about protecting your pensions. So I think most of you have probably heard the phrase cash is king, but here information is king. So today we're going to talk about knowing what you're entitled to, what your spouse may be entitled to, and that will give you the best shot at protecting your pensions and much more. Next slide, David. So the first question that a lot of people ask when we're discussing pensions and accounts is what happens to them when you're going through a divorce? And the most important thing to first understand is what accounts we're actually talking about. So there's two real categories when we're referring to retirement accounts that would be under the umbrella of marital assets to be distributed in a divorce. The first is a defined benefit plan. And now this is your typical pension. It's an employer-sponsored account where you are guaranteed the benefit when you retire. Now, there's secondly an umbrella of accounts called defined contribution plans. These plans are more employee controlled. They are based on what you contribute, and then what you contribute is subject to market forces on whether or not it grows or it shrinks. So these are the two accounts that we're really discussing, the two categories of accounts that are subject to distribution in a divorce. So how do we determine what exactly your spouse will get from these two plans? Well, they're actually treated differently. So in a defined benefit plan, your pension, you'll hear words such as Majowskis and coverture fracture, and you'll be scratching your head and saying, I have no idea what these people are saying. It sounds like they're talking a different language. So for Majowskis, the people are referring to a case that went before the Court of Appeals in New York. Now that is like the Supreme Court of New York. It's very confusing here. We call it the Court of Appeals, but it's the last stop in who makes decisions in the law. So Majowskis v. Majowskis was a case that went there, and they said, how do I divide my pension? What does my spouse get? And they came up with the term coverture fracture, or fraction. That means that they will take the amount of years that you have on the job versus the amount of years that you have on the job while married. And that's a very important distinction because the time period of where you're married comes up and gives us that fraction. So for example, if you have been on the job for say 10 years, but you've only been married and on the job for 5 of those years, then the fraction will be 5 over 10, 50%. That is the coverture fracture, the marital portion of the pension of which your spouse may be entitled to a portion. Generally speaking, the courts usually find that 50% goes to your spouse of that fraction. But this is still negotiated in a divorce. You can go higher, you can go lower, it really depends. But generally speaking, it's about 50%. Now, when we're talking about defined contribution plans, we're talking about things like your deferred comp, an annuity, a 401k. We have a bunch of the different accounts listed here that would qualify under a defined contribution plan. So we are looking here at what contributions you are making to each of these accounts. And we categorize them in 3 different ways. The first is premarital contributions. These are monies that are deposited into the account prior to the date of marriage, and these are not shared with your spouse. The second is post-commencement contributions. These are monies that are contributed to any of these accounts after the filing of the divorce, which means that there is something called a summons or a summons and complaint that notifies the court, I am seeking a divorce or my spouse is seeking a divorce, and it's known as the cutoff date for when these post-commencement contributions are categorized as that. The real important contributions that we're talking about are those that are made between these 2 dates, between the date of marriage and the date of the commencement of the action. Those contributions are subject to equitable distribution in a divorce. In addition, whether or not these contributions grow or they shrink are also something that is subject to equitable distribution in a divorce. Now, how does this get from your account to your spouse? Well, it's distributed by something that you may have heard. It's called a QDRO, and it actually stands for Qualified Domestic Relations Order. You can see here on the bottom, we'll more than likely refer to it throughout the rest of this as a QDRO. It's just easier and somewhat fun to say. So that is what we're referring to and the mechanism that transfers the account. So when we're talking about pensions specifically, the defined benefit plan, there's a lot of frequently asked questions that we get. So we've already talked about the Majowska share, and we've talked about the coverture fraction. The next question that we get a lot of the time is, who pays the taxes on this? You know, we take out money during the time before we're retired. I'm going to get hit with a penalty from the government saying, you can't take that out without paying me something. Well, that really takes us into what exactly is a QDRO and how does that function? So like I said, the QDRO is the mechanism by which the court says to the pension administrator, you take this money that the spouse is entitled to and put it into a separate account. That QDRO is something that is an order that is created and then submitted to the judge for the judge to sign off on, and then gets submitted to the pension administrator in order for them to split the account. But who prepares the QDRO? And what are the terms that go into it? How does this all come about? These are items that are generally negotiated within the confines of the divorce proceeding. The majority of divorces resolve by you and your spouse coming to an agreement as to all of the aspects of your divorce, your assets and your liabilities. Your retirement accounts are one of these things. So when you're negotiating that, there are certain terms that get put into this final agreement called a stipulation of settlement in order to effectuate the money that your spouse is entitled to going from your account to their own account. And the courts typically allow us to work with outside companies in order to prepare this order. There are a few of them that have really cornered the market, especially in New York State, that everybody uses. And if you come to us individually, we'll talk more about which companies are better, which are a little bit, more expensive, things like that. But these companies are employed to prepare a QDRO in line with the account that they're splitting, meaning that it could be a different terms that are necessary to be included depending on which account and where it's held and who the pension administrator is. So that company would prepare the QDRO, and then it would be reviewed by you, your spouse, and if both of you have hired attorneys, your attorneys as well, to make sure that it's in line with what you've agreed to in your stipulation of settlement, and that it effectively can get the money from one place to the next. Next question we get a lot is, how much does this cost and who pays for it? Well, it really depends. It depends on how many accounts that you actually have, how many accounts need to be split, and whether or if you need a QDRO for that or not. So it can run you anything from a few $100s to several $100s, if not more. But it's much smaller and focused amount in what you're doing than the divorce that you've just been through. So who pays for this amount? In general, we like it that both parties, meaning you and your spouse, equally share in that. You're dividing a marital asset, and that is something that you both are getting a benefit from. However, this is still a negotiated item that you and your attorney and your spouse and their attorney can come to an agreement. You know, we've seen it where everybody does equally. We've also seen it that one person pays where they're getting the benefit from the splitting of the account, meaning that they're the person receiving the money. But it's something that is worked into the larger agreement that you have regarding your divorce. How long does this take? It's a tricky question because it really depends on some factors. It depends on your pension administrator and how quickly they can get the information to the outside company that prepares. It depends on you and your attorney because you need to approve whatever the QDRO draft is that you're receiving. And then it also depends on the courts. These orders go to the judges in order for them to sign off on them. And that is something that usually is a quicker timeline than other items such as a judgment of divorce for them to sign, but it's still up to the will of the court and how fast they are on that day. You never know when a clerk is going to be out sick or they're hiring a new clerk for when things get a little bit faster on the train of going and getting this done for your benefit. But usually it takes a few months in order to get this done. Now, when is the right time to do a QDRO? In my experience, it is as soon as you are able to do a QDRO. There have been plenty of times where people have come and have never actually done the QDRO. They have gotten divorced, they have their judgment, and now it's just several years and everybody kind of forgot that there was this outstanding issue to be taken care of. And people can be in payout status and receiving money, and it just causes all sorts of complications. So the right time to do a QDRO is as soon as possible. However, you're a little bit backed up until you get your judgment of divorce. The pension administrators really require that you have a judgment of divorce in order for them to split the account pursuant to a QDRO. So that is something on the timeline that you do have to wait for and make sure that that is taken care of in order to get the QDRO effectuated, signed, sent to the pension administrator, and to split the account. We also have gotten a few questions about what happens if I go out on disability. Now, there are two different types of disability. You have your ordinary disability and you have your accidental disability. Ordinary disability is when you have an illness or an injury that prevents you from working. Accidental disability is getting hurt on the job or an accident. Both of these disabilities have a hypothetical component based on the length of service, the length of time that you've worked on your job. And that component is something that your spouse would be entitled to. They would not be entitled to the component that is dealing with the personal injury aspect, but it's something where there is a fraction that is determined based on that length of service of what they would be entitled to. Now, we have a little bit of different frequently asked questions when we're talking about a defined contribution plan. Those defined contribution plans, as we've talked about, do not get divided with the Majowskis formula. You know, that funny named case that we talked about before. That formula does not come into play here. This is more about the contributions that are made during the marriage and then are adjusted by market forces, whether they go up or down. This is very dependent upon the market and no control, quite frankly, to you if it's having a good day or a bad day in the market. In a long-term marriage, It is sometimes easier, though, to look at the contributions that were made before the marriage, adjust those by market forces, and then back them out of the total amount. It's a much smaller amount and generally easier to then define exactly the amount that your spouse may be entitled to rather than doing it the opposite way, because you're looking at a larger amount of contributions that are made and it makes everything a little bit smoother. These accounts are also divided by a QDRO, the Qualified Domestic Relations Order, and would need outside companies to help you be able to effectuate that. Once the QDRO is done, it's sent to the pension administrator. It needs to be split and set up for an account for your spouse. These are generally going into an IRA that your spouse would then be able to get. Now, I think I mentioned earlier the taxes that come with taking out early withdrawals from any of your accounts. The best part of the QDRO, the reason that the courts came up with it, is that it says to the government, this transfer, this money that is going from my account to my spouse's account because we're getting divorced, is not taxable. Do not assess any penalty. This withdrawal is not something that I have to pay the federal government for. Once that money is in your spouse's account, however, that is something that any withdrawals at that point, your spouse is subject to the rules and regulations of the tax code, and there are tax penalties assessed if they take out that money any earlier than retirement age or what the pension administrator rules are. So that is the best part and the most necessary part for the QDRO. Without it, there are tax penalties that are assessed, and nobody wants to deal with that. But there are complications that come up, and I think that this is what David is now going to take over and talk to you guys about.
Okay, great. Thank you, Erica. That's an excellent primer on everything that happens to your retirement accounts if you're getting divorced. Good afternoon, everybody. My name is David Gross. I'm a partner at the firm. I've been working exclusively in the divorce and family law field for just about 15 years. I'm going to talk to you about what can easily go wrong with distributions of your retirement accounts in the context of a divorce, and some of the tools you have at your disposal to help avoid these problems. Some of these tools are geared toward people who haven't gotten married yet. If you're already married, don't worry, you aren't completely screwed yet. And if you're already involved in a divorce or you're about to be, there are still some tricks that can help streamline some of these issues. So the first wrinkle is that the law says if you can't prove your separate property contributions, those funds that you had in your 401k before you got married, for example, you don't get to protect them. They get chopped up just like the rest of the accounts. Another issue is that your plan administrators, as in many industries nowadays, will no longer calculate gains and losses on your defined contribution accounts, the annuity, the 457, deferred comp, stuff like that. What do I mean by this? The money that you put into these accounts before you got married isn't just sitting there like a lump, right? It's growing, hopefully growing in the market every day. So if you have to trace that growth in order to recover it and protect it, you need to pay an expert to do that for you, which just contributes to more cost and more time. Lastly, another common issue that we see is the loans that are taken against your pensions. Miraculously, your spouse will lose all recollection of the details about these loans during your divorce. Why was the loan incurred? When was it taken? Where did the money go? You're going to need to remind your spouse with proof, and then we're going to need to negotiate the who and how and when those loans get repaid. Okay, so how do we help avoid these issues? First, and I'm going to go into all of these in greater detail, but first, keep it clean. Keep copies of all your records. Don't mix your separate money with your marital money. Second, be creative. Get appraisals done so that you can consider different types of options rather than just the QDROs that Erica spoke about. Maybe your spouse will give up his or her share of your pension in exchange for your share of the home or some other asset, etc. And keep your case away from the judge because we all know what a judge is going to do here. And finally, plan ahead. Hope for the best, plan for the worst. Prenups and postnups are wonderful tools to help avoid all sorts of these issues. Okay, what do we mean when we say keep it clean? Keep the separate property away from the marital property and keep the gains and losses clear and simple. How do you do that? If you're already on the job when you get married, ask your plan administrator right after you get married to create new accounts for your defined contribution plans, like your deferred comp, etc. That way, the new account that you make will be completely marital, and the old one and all of its growth that accumulates over the years will be completely separate. So this is much less complicated when you're getting divorced, much easier to do the distributions. And do the same thing when your divorce starts too. That way, when the brand new account filled with the post-commencement contributions will be totally yours, and the prior account, the one from during the marriage, and any of its market fluctuations that take place during your divorce will be easy to distribute without complications and experts. If you do those two simple steps, you will not need to pay an expert to conduct a tracing method, and I will have saved you $1,500 to $4,500. Okay, next tip is don't be afraid to get creative. The system wants you to do things in a boring cookie cutter way because it's the simplest thing for judges and lawyers. But that doesn't mean that it's right for you. You can retain an expert for a few $100s to determine the value of your pension. Now, what they're doing is they're looking at your hypothetical monthly benefit if you were to if you're somehow able to immediately retire, even if you don't have all your years in. And they're figuring out how long you might collect that for using actuarial data and all sorts of formulas, discounting for present value, et cetera, et cetera. And basically they come up with a price tag. And that's what your pension is allegedly worth today, if you could somehow sell it to somebody. And you can take that figure and you can use it to help cut a deal in your divorce. So you might say, hey, you let me keep my pension and I'll let you keep fill in the blank, whatever makes sense and is fair. House, an apartment, cars, bank accounts, your retirement accounts, whatever it might be. And having the values of all of those things makes that negotiation possible. Pro tip, if you are going to get your pension appraised, please get it done very early in the divorce process. Do not wait. If you get it done quickly, again, for a few $100s, you can really short circuit the whole process, which will help you avoid delays and help save money. Even if your spouse is dragging things out, it'll help you show the court that you're being proactive and you just want to get this thing resolved. And that is something that every judge wants to hear, trust me. And keep the case away from the judge. I'm a big fan of mediation as a tool for innovative and inexpensive resolutions, but it doesn't even have to be mediation. Just start negotiating very early on so that you can reduce the chance of having the case go to a judge. Because you have to figure it this way. Judge may have, say, 250 other cases. And for 249 of them, that judge is dividing retirement accounts with a QDRO. Judge is not likely to do anything different in your case. And also try to understand what your spouse is going through. Divorcing spouses are often ruled by emotion, by fear, anxiety, not knowing if they'll have enough money to survive. And that goes for the people doing the paying, not just the people receiving that money. So try to understand your spouse's mentality about things and why they feel the way they feel, as it may help you unlock the right path for a resolution. Okay, for the next creative concept, I'm going to hand it back to Erica, tell you a little bit about postnuptial agreements, and then I'll be back to talk more about prenups.
Thanks, David. So you've heard about what actually happens when you're splitting the retirement accounts. You've heard about some of the complications. Now, what do we do? What do we do if you're already married? That is a common question that we do get. And there is a tool for that, and it's called a postnuptial agreement. So a lot of the questions that we will get is, what is a postnup? How does it work? Why should I get one? And what happens even if we get divorced? These are all questions that need to be answered and can help you protect your pensions, your assets, even liabilities if you want to keep your debt. Now, a postnup. This is a binding contract that you and your spouse would enter into that would create ground rules for the rest of your marriage. These will include what to do with your assets, who's entitled to what. If you came into the marriage with some separate property, it could outline what exactly that separate property is in a formalized document, so that way you don't have to quibble about it later on down the road. This can also set rules for how you deal with your joint bank accounts, your income that's coming in, any other assets that you acquire during the length of your marriage. This is a great tool to build back trust in a relationship. There are times in a marriage where you and your spouse may end up having different expectations as to the financial life that you now have, which is now dependent upon each other. You may want to set the rules for how each of you should react and should obligate yourselves into dealing with those financial questions throughout the length of your marriage. And maybe this was something that you didn't talk about before you entered into the marriage, but now it's coming to light based on a lot of different issues that have come up. This is also a great tool to reduce tension in your relationship. A lot of tension comes from the questions of financial uncertainty, or who does what with what amount of money, or whose income goes into what account. The postnuptial agreement is something that could reduce the tension that is created by uncertainty, not having the answers to these questions. It's very important, though, that each of you, in coming together and having a postnuptial agreement, are represented by attorneys, and that you exchange financial information as to what your assets are and your liabilities, so each of you can be educated as to the decisions that you're making moving forward. That's also important for if things don't work out. If they ultimately do not work out, this postnuptial agreement can act as the final agreement in your divorce. It's an easy way to streamline the process and to define exactly what your rights and obligations are to each other without incurring too much financial expense, as well as the emotional expense that does come with divorce. So these are some great ideas for if you're already married. There's also questions about what happens before you get married and how you deal with that. And so David's going to talk about that now.
Awesome. Thank you, Erica. I'm going to tell you about those prenup agreements as sort of the last creative measure today to help protect those pensions and your other retirement accounts. There's a lot of misinformation out there about prenups. We've gotten a lot of questions today, and over the course of my career, I've answered these questions so many times. Who can have one? Are they enforceable? How do you ask for one, et cetera, et cetera. So hopefully we'll dispel some of the myths about prenups today. So the overarching principle, the main goal of every prenup should be, if we have to get divorced, let it be fast, easy, and inexpensive. That's always the goal when we are negotiating terms of a prenup. Sure, maybe there's going to be a specific term in the prenup that might be something that costs you money in your divorce, but you won't have to fight about it later. And that makes the divorce itself faster, easier, cheaper. There's 4 major parts to most prenups, some of which are optional. First and foremost is the definition of separate property. What gets shared, what doesn't get shared. Obviously, that's a very important part. Second, which is optional, is your obligations or your ground rules for the marriage. How much do we contribute to joint accounts? Do we rent or buy, et cetera, et cetera? You can pre-agree when you're happy and in love to the issues that many couples otherwise fight about during a marriage. Third, also is optional, will work hand in hand with your will. You can decide in advance, in case one of you dies during the marriage, what types of assets go to the surviving spouse and which ones don't. And finally, what happens if we get divorced? How are marital assets divided? Does anyone have to pay what we used to call alimony? We call it maintenance now, by the way. Again, better to agree to these things when you love and trust each other than when you're screaming and crying and paying lawyers to duke it out in court. So people ask me all the time, should I get a prenup? Should I bother? Is it worth it? The best way to answer that is this illustration. Here is a divorce without a prenup. Nothing has been predetermined. Everything is up in the air. There's no certainty. There's no clarity. Who knows what's coming? You and your spouse are being asked to make major decisions when you're feeling mad, hurt, angry, betrayed, even vengeful. This is not the best time for rational decision-making processes. If and when you can't resolve things, the judge, who does not have enough time or energy to really get to understand your particular circumstances and handcraft a decision for you, is making decisions that are going to affect the rest of your lives. This is not ideal. And of course, all of this can make for a far more expensive process. On the other hand, if you've executed a prenup, you've already predetermined how most of the issues will be resolved. So you have certainty, predictability. And you made sound decisions when you were open and trusting and in love, not clouded by hatred. And the judge doesn't have to make as many decisions, if any. Again, certainty, predictability. And all of this adds up to a much less expensive process. Okay, parts of the prenup. So first we talked about is the definition of separate property. This is extremely important. New York State gives us a very narrow definition. It's not very protective. The state wants almost everything to be marital property and get divided in your divorce. The only things that are protected as your separate property are premarital assets, meaning what you brought into the marriage, gifts from non-parties like your parents, for example, money or property that you inherit, proceeds from a personal injury, and the sale or exchange of other separate property. So in the prenup, we normally expand this definition to give you much better protections. So very commonly, we add retirement accounts, pensions, 401ks, etc. We can add income that you earn from your job, which, by the way, otherwise would be marital property when it lands in an account. Your businesses, and all of the gray areas, meaning the things that may change in the law or when the law doesn't really have a clear answer or it's iffy. Lawyers love gray areas because that's where we make our money, fighting about stuff, right? You don't want gray areas. And these are just some of the examples of popular separate property expansions that we do. And of course, all of this is so important because once something is classified as separate property, the court cannot divide it in your divorce, and the court cannot order you to sell it in the divorce either. So part two, again, something that's optional but becoming a lot more popular, is setting your obligations for during the marriage. You can create ground rules that you each have to follow and decide things in advance, like how to share expenses, how much to spend or save, whether to rent or buy, or how you'll pay the down payment if you do buy, or how much to contribute to retirement accounts, for example. And you can avoid these fights by deciding them in advance and having them memorialized in your prenup. The next part is obligations upon death. So again, this works with your will and basically is ground rules for what you can and can't put in your will. So you can predetermine what happens if one of you dies during the marriage. Does the surviving spouse just get everything? Or what about all that separate property that we've been talking about? Many people want to have flexibility so that you can leave your property to somebody else, maybe a relative or a parent that helped you financially, or children from a prior relationship, etc. So this gives you rules for what you can and can't say in that will. And you may have also heard of the right of election. That's the rule in New York that says you have to give your spouse at least a certain amount of money, your assets from your estate when you die, if you are still married. But in a prenup, we very often waive that right, or at least waive it as it pertains to separate property, which will give you more flexibility in terms of how to do your will and how to structure your estate. And of course, finally, what happens if we get divorced? The prenup will govern what happens to everything, keeping your separate property, how your marital property will be divided, whether and how much maintenance you have to pay, whether and how much you have to pay in legal fees for your spouse, etc. Maintenance is paid based on a formula now, but you and your fiance can waive that formula. You can make up your own formula, or you could do something completely different, or pay each other nothing. You can waive it completely. The same goes for legal fees. There is a presumption in the law that the person who makes more money will pay toward the other person's legal fees. But that too can be waived, or you can pay a specific percentage or a specific amount. And all of those terms can be put into your prenup to help you, yes, have a quicker, easier, and cheaper divorce. My suggestion is make these decisions now when you're happy and in love, rather than when you don't trust each other at all and you're paying lawyers to fight. You don't have to take my word for how bad divorce can be. I guarantee you that you have a friend, family member, a coworker, a neighbor, somebody who went through an awful divorce. And by the way, that's my favorite way of introducing the topic of a prenup with your fiance. We have to make sure that we don't go through what so-and-so went through. I never want to go through that with you. The prenup could be a tool to help keep things easy and amicable with your ex for the benefit of a future relationship, especially if you have children together. Thank you so much. That concludes our formal presentation. We are very happy to stick around and answer questions though. And I just wanted to say, we do have a nice promotion for you folks. If you mention that you attended the webinar today, we will waive our consultation fee, and we will also reduce our rates that we charge if you decide to retain us. Just a little thank you for letting us speak with you today.
Thank you so much, guys. Now, please, guys, remain online because I'm going to ask a couple of questions and then I'm going to talk a little bit about Financial Club news. David, Erica, I got some private messages that were sent to me via email and private messages. And I was wondering, while I'm reading some of those messages, if maybe one of you can check the messages in the chat that was sent to everyone. It will be just a little bit easier, and then address those questions if you don't mind. It's the chat option on the bottom.
Yeah.
Okay. And what I'll do is I'm going to just ask a couple of questions, and whoever wants to jump in and answer them, if you don't mind. So one of the questions was, can prenup be voided for any reason?
For
various reasons.
I'll tackle that one. So I think if the question is, can the court throw out a prenup? Can a prenup get vacated? The answer is yes. And if you do it wrong, or it is so incredibly one-sided, a judge has the authority to vacate the prenup. So when I say doing it wrong, there's a number of things that you can do to do it incorrectly. But having an attorney draft it and having your spouse or your fiance, I should say, at the time, review it with an attorney is the best way to knock those out of the park. Because the excuses that we hear later on is, I thought he was my attorney too. I didn't realize this. We didn't disclose that. She didn't say that. All the things that would be prevented by doing the process properly. Being represented by counsel, if that person is not a native English speaker, having a translation, making sure that everything is explained and disclosed. You always want to come forth with everything, all your assets and debts, because you never want the other person to be able to say, oh my gosh, if I had known blah, 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 I would never have signed this.
Got
Also,
it.
do not sign your prenup days before a wedding when you've got the hall booked and your family's coming in from out of town. All of that pressure contributes to an environment where a court may say, basically, you didn't really have the full capacity to understand what you were signing. Those are the major instances that we see prenups get thrown out. That and something that is just so manifestly unfair that the person who is getting screwed might end up on welfare because they're just in such a terrible position. Those are
Got
the
you.
ways that prenups can get invalidated.
Awesome. Now, another question is, we have a lot of members of service that are married to each other and both sides have pension. So how does that work during divorce? Like if both sides have pension?
So I can answer that. If you and your spouse both have retirement accounts, then you're both entitled to a portion of the other's account. So a lot of times what people will do is say, you know what, we've both been working the same amount of time, roughly making the same amount of money. There are times people say, you know what, I don't need to know how much is in there. Let's just say you keep yours and I'll keep mine. But then you get attorneys involved, and attorneys will say, wait a second, you need to know how much is actually in these accounts before you say, I don't want what my spouse has because I want to just retain what I have. So a lot of the times what we'll do is we'll get an appraisal done. I think David spoke about this a little bit when he was discussing it, that you want to get the value of what's in your accounts as early as possible when you file for a divorce. That will give you the knowledge of knowing how much is in the account, so you're better able to know what you and your spouse would each be entitled to. So if you have been working for a significantly longer period of time than your spouse, but you were married throughout the length of it, then it's likely that you would be having to provide your spouse with a larger amount of your account than you would receive from their account. In those circumstances, people a lot of times will just have QDROs for both accounts, or you can streamline it, get the values of what it is, and have an exact dollar amount in just one QDRO to be able to make this a more seamless process.
And can a portion of, or actually everything, instead of going to a spouse, be diverted towards the kids?
In terms of retirement accounts,
Yeah.
well, that would have to be a negotiated term. When you say can something happen, anything can happen if everybody is in agreement about it, more or less.
Mhm.
But that's not something that a court would award. Believe it or not, there are far greater protections for a spouse than for children in most of these contexts.
Got it. Can a spouse waive a rights to a pension? Is there such a form?
Sure. That is something that just delves into what David was speaking about. If you guys want it, it will happen. It's a build it and they will come situation. This is this is something that if you and your spouse are in agreement that you say, you know what, I don't want your pension, you don't want my pension, or you just want to waive off on theirs, a lot of times there is a form that the pension administrators or the retirement account administrators will have where the spouse needs to elect a certain paragraph in order to allow for that to be waived off. So in the future, there's no issue moving forward with the account just being yours. And that will also be a comparable paragraph or several paragraphs in a stipulation of settlement which would also codify that right. So you not only have it in the agreement that you're doing for your divorce, but then you also have it on notice to the pension administrator. So there's no hesitation in moving forward when you actually retire in receiving the amounts that you're entitled to without somebody saying, wait a second, there was a divorce that happened and we need to see what's going on with that. They would know ahead of time.
Okay.
I would just piggyback on that. Please do not rely on pre-printed forms from plan administrators that waive or ask someone to waive very significant rights. There is a lot of case law. This is a very complicated body of law. We have a case pending right now that deals with this exact issue, and it is my belief that such a form, if it does not meet the very specific statutory requirements under the domestic relations law, which frankly it probably doesn't, you really should have a postnup, or if you're dealing it in a prenup, that's fine too. But if you're doing it after you're married, a postnuptial agreement does not have to be long and complicated. But if you want someone to waive pension rights, please do it in an agreement, a formal written agreement that's duly acknowledged with the formality of a deed. Oftentimes that form that we're talking about doesn't get that done.
Got it. Another question was, for tax purposes, pension benefits, do they get added to that person's income?
That's an interesting question. If I understand it right, I think you're asking about what we call the alternate payee, meaning not you, the pension holder, but the other person who is receiving
Right.
that pension. Typically, that is taxable income to that person, even if it's not taxable income to you as the participant.
Okay. And as far as inherited IRAs, are they subject to being split?
No, inheritance is separate property. What I would beg everyone here to do is, which I mentioned earlier, keep them separate. Do not then make a contribution from your paycheck into an IRA that you are trying to say you inherited, because what happens is you have then separate property funds and marital property funds, meaning the money that's coming from your paycheck, and you're mixing them together. It's a problem called commingling, which then it becomes a whole legal battle. It is much easier, just if you inherit something, leave that alone. Don't make any contributions to it. It's fine to withdraw from it if and when you need to, but if you want to have your own, other account that's going to be marital, that you created during your marriage, do not mix those two streams together.
Okay.
And I'll just add as well that you want to keep all the documentation, like David talked about earlier, with respect to anything that's inherited or gifted to you. Banks generally keep documents for about 7 years. So if it's longer than that you were married and this occurred prior to 7 years, you're going to have a very difficult time in proving that certain things are separate unless your spouse agrees with you that they know that that was something that was separate. So keeping the documentation, especially from years prior, is crucially important in making these decisions.
Another one that I'm getting, in separation agreement through a divorce mediator, it was highly favorable in the person who is asking favor. In that case, there was a pension waived, home 50/50, no child support. Can this be contested later on?
A mediated divorce agreement. I mean, any divorce agreement, somebody can try to say that it should be thrown out. But like I spoke about with the prenups, there's only very limited circumstances where you can win in that kind of claim. If you do everything right, and it's going to be very hard to vacate. You have to really shock the court with something that is so incredibly unfair if that's the ground that you're going to use. If you're going to say somebody coerced me because they threatened me, or they had a gun on me, or all the other things that we hear, those issues are always in play. But there's no requirement that the settlement has to be basically 50-50. You know, a court will not throw it out because it's 60-40 or even 70-30. It's fine. It's fine to settle a case that's not equal. It just, when it's so incredibly disparate and leaves somebody in a position where they could be a public charge, where you have to worry a little more about that.
Okay, and is domestic relation partnership this rules the same or it's different?
A
So that's
domestic,
not partnership yet. That's not the same entitlements that you get between a domestic partnership and a marriage. A marriage really entitles you to a lot more of the economic advantages than a domestic partnership would. So when we're talking about equitable distribution, we're talking about marital assets that are obtained during your marriage. It's not the same standard that we're talking about with the domestic partnership. So those are some of the big differences between the two.
Okay, and another question that was sent privately to me, if someone gets married, let's say after 10 years on a job, and then they get divorced 10 years later, it's only that 10 years that spouse can go after? And if it is, like, is there a formula that they use to calculate how much the spouse will be getting?
Right, so that's actually what we had discussed at the very top of the webinar. That is the funny named case known as Majouskas. They take the years that you were paying into, that your pension was accruing money. I think somebody said to hold on, so I just stopped. But bottom line is that it's the years that you were contributing while you were married over the years that you were contributing. So it's a fraction where if you are, say, married and working and contributing for 5 years, but you were working and contributing, but not married for 10 years, or 10 years altogether, you were working, it would be 5/10. So it'd be 50% is the total amount that is up for grabs. The percentage of that, of what your spouse is entitled to, is what can be negotiated and is typically known as 50%.
Got it. All right, and then there were a bunch of questions in the chat, if you guys can address that too.
yeah, I'm leafing through them, and you know, again, a lot of these are very personal, and I'm going to try to shy away from the ones that are unique to your specific situation. That's better for a consultation or, you know, a private call. I did see a great question that we actually didn't touch on, and Erica, maybe you want to deal with this one. Someone asked, what happens to pension distributions when one of the parties passes away?
Well, this is a question that has come up a lot, and it actually, depends a lot on whether or not the pension's being paid out at the time that somebody passes. And it also depends on the pension administrator. So there are pension administrators that say that if the party dies prior to the pension being paid out, meaning the person whose account it was, if they pass and the amount has not been paid out yet, then it reverts back to their estate. That's what a lot of the pension administrators have in their rules. If you are in payout status, if you're already receiving it, then you generally will continue receiving the benefit that you have. But the real tricky part is when they die and you actually haven't been paid out. So this is something that you really want to know the rules for what the account is, which can be, David and I were actually talking about this right before we got on the webinar. You can request the summary plan for each of these accounts to know exactly what the options that you have are with respect to some of these items, and that would be listed there because they do vary from account to account.
And also, those are items that are going to be negotiated in your divorce. Typically, if you have a long-term marriage, your spouse, what we call the alternate payee, is going to be entitled to some death benefits. So you may be as the participant, you may be directed to choose one of those options where when you pass, your spouse gets to continue collecting. Obviously, there are many different options and the different tiers and all of that. So again, those summary plan descriptions lay all of that out, but those are items that are very regularly negotiated in the divorce.
I had another good question. what happens if two people get married after they retired? What happens to their 457, 401, and the pension? Are the other party still entitled to that?
Well, the answer is no, because if you get married after you have retired, those assets that you created are all premarital assets. So whether it's your pension or your 457 or whatever, those assets were created completely before your marriage. So your spouse is not entitled to any share of those assets. Where it may get a little bit hairier is when you're getting that monthly pension check, for example, and you're depositing it into an account. Maybe you're saving it up. Maybe that account is growing, or maybe you use that money to buy a home or some other asset. That's where things get a little murkier, because we're dealing with tracing separate property and what happens to it after that. There's not a very simple answer. But in terms of the assets themselves, that 401k that you funded before you got married, that pension that you worked in and contributed into before you got married, that's all, in the premarital column, not to be shared.
Now, if someone is getting divorced, should they still contribute towards the pension? Is there a point?
Yeah, I mean, if you have available income and you can contribute to your different accounts, absolutely. One of the tricks I mentioned is asking your plan administrator to create a new account, because that way, that one that you are now funding after the divorce started is very clearly and cleanly your separate property, post-commencement contributions, whereas the ones from during the marriage is the part that's going to get split up. If you've got the disposable income, no reason not to.
There's two very important dates. It's the date that you get married, and it's the date that you file for divorce. Anything before the date you got married is your own money. Anything after the date that you file for divorce, that is your own money. The trick, like David keeps talking about, is that you want to keep these things separate. You don't want to commingle them to make it more difficult to people to know which dollar came from money during the time that you were married and which dollar came from money from before you were married or after the divorce started.
And there is no time limit when you can do prenup, right? It's not like it has to be done a month before the wedding. There is no time frame, right?
There's no specific rule about that, but again, I would advise doing it early enough so that you don't have that wedding date looming. Because if it's right on top of you and you're signing something days before a wedding, it enables somebody to later say, I wasn't paying attention. I was booking the hall and the florist and the family was coming in and there was so much pressure, and you don't want to have those arguments. You want to have very simple, clean, I would recommend, if you're getting married this summer, this is a great time to start. It's March 25th. If you have a June 25th wedding date, this is a great time to start, because it's going to take a little while to prepare it, to negotiate it, to go back and forth, and then sign it. And if you're signing it in May instead of June, or instead of the night before the wedding, that's all the better.
And as far as, is there a time frame where you have to be married for a certain amount of years before you qualify for someone's pension, or it can be just one day and that's it? Now you're stuck paying, is there such thing as a time frame, like how many years you have to be married before a person qualifies?
There's no minimum time frame of when somebody qualifies. It's not like a non-vested pension or vested pension issue. We're talking about, though, the money that's accrued during that period of time. So if you're married for a day and then you said, you know what, this was a mistake, it's extremely unlikely that there would be any money that person would be entitled to, because there wouldn't have been money accrued in these accounts. But say you're married for a year to somebody. During that year, if you are talking about a defined contribution plan like a VSF or a 401k, you are then contributing money that you earn during that year into this account. And that's the amount of money that your spouse would be entitled to a percentage of. And just like the pension, when we're talking about a Majowskis calculation, the fraction is based on the amount of time that you were married and contributing to the account. So that 1 year would be the numerator, whereas the denominator would be the length of time that you've actually been working. So it's a much smaller percentage that your spouse would be entitled to, but there's no minimum time frame for when your spouse would be entitled to that money. But it is important, if this is something that you want to make sure that you can protect, that you talk to your spouse about this in a prenup or a postnup, because that's the way that you can protect these accounts and have them say, you know what, in a divorce, you keep yours and I'll keep mine. That's the one sure way that you can protect them and say, you know what, I have it right here in writing, it's signed, it's notarized, it's done in the correct fashion, and there's no more discussion or money spent on this issue because we have already agreed.
Okay. And as far as the disability, because we have some officers that receive line of duty disability, pension also can be a part of, I guess, settlement, or for disability cases, it's different rules.
Well,
So-
with the,
Go
you
ahead.
go.
What they do is the disability part is not shared. But what they do is they will say, we're going to create a hypothetical number that if you retired today and you weren't disabled, you would get something. And that hypothetical amount is what is going to be shared by the QDRO. So to the extent that there's more for the disability, that is excluded. That's the participant's separate property. But the hypothetical service component is the part that gets shared.
Got it. There was one question about how you create a separate account. Louis, that's something that I can address. I'll guide you. Just give me a call afterwards and I'll tell you how to do it. So there was a few more messages in the chat, if you don't mind, if you can address them.
Yeah, there's a lot. I'm trying to keep up. Someone asked, when you have the QDRO prepared, does it automatically get sent to the pension section? No, that's something that the attorney will take care of. The process, really quickly, the process goes like this. The company that you hire prepares the QDRO. Everybody takes a look at it. They say, okay, looks good. Then it goes to NYPD for what they call pre-approval. NYPD reviews it, says, okay, looks good. It comes back. Then we file it with the judge. Then the judge signs it. And we get the signed copy back. And then it goes back to NYPD as a signed certified order. And that's when the if it's a defined contribution plan, that's when the money starts getting divided. If it's a pension, I assume it goes in your file. And then when you retire, that's when they start, splitting those checks up. Somebody asked, does the ex-wife gain interest on her share of the pension as long as I'm still on the job? If you are already divorced, that's cut off already. So if I'm understanding the question correctly, working more is not going to impact you once you're already divorced. And then my other question is, my QDRO was already done. I'm confused as to what her share should be. That's something we could talk about offline, I think. We can hash that out.
There's also a theme in a lot of the questions about what happens when you contribute after you're already divorced or you file for divorce. Those contributions in a defined contribution plan are not subject to be shared with your spouse. In a pension, the numerator, it already is cut off by the length of time that you were married and contributing. So for the longer that you are contributing and after the divorce, it actually decreases the percentage of which they would be entitled to.
Thank you. Someone asked, is child support and maintenance in addition to pension? Yes. When we're talking about splitting up this pension, this is a equitable distribution issue, meaning dividing assets. Child support and maintenance are completely separate. That's based on comparative incomes and things like that, which would be the subject of a whole other talk. We could get to that another day. I'd be happy to talk offline also.
This is a good one. Does a legal separation stop the clock with the amount of years counted in the QDRO? So yes, a separation agreement can signify in detail the date by which you stop having any sort of economic partnership that your spouse would be entitled to the money in your accounts. So the legal separation is very similar, in fact, to a postnup, where it can outline what exactly your entitlements and obligations are to each other.
Trying my best to read through the questions, but they're coming in fast.
Yeah.
Domestic partnership we talked about. I apologize. I'm moving past questions about maintenance or child support because they're just a little off topic. But again, we'd be happy to talk about those, separately offline in a consultation. Disability pensions we talked about. Go ahead, Erica.
There is a couple of questions about if you're already divorced, but if the QDRO hasn't been done yet. So your divorce agreement would actually outline whether or not that was something that you guys agreed to, or if you waived a retirement. Your divorce agreement, the stipulation of settlement, is a guidepost for what actually happens next. So I'd encourage everybody, if you're already divorced, to review that to know exactly what you are entitled to moving forward, or what you don't have to be entitled to, or what your obligations are. If you still have questions, you can come talk to us about it.
I see someone asked if divorced after retirement, will variable supplements still be divided? Yes, if you created that asset during the marriage, it's still subject to equitable distribution.
There's a question here about common law marriage. That is not in effect in New York. So we do not have common law marriages. If you are married in either a religious ceremony or a civil ceremony. You can have a license. There's no other way for the courts to determine that your marriage is legal and valid if you've just been living together with no ceremony.
And if someone gets a disability pension, do they still have to pay child support?
So that's a separate, those are really two kind of separate issues. If you're receiving a disability pension, your income is then used to calculate what your child support obligation would be. That is the easiest way to do it. However, the courts can say, you know what, your disability amount that you're getting, maybe that's not the only thing we need to look at. Are there other sources of income? Or do you have the ability to work outside of this? So there are similar questions that can be asked beyond just what that amount would be. But child support is always going to be paid by the court. There's a public interest, there's a vested interest that children are supported by both parents. And so the courts will never say you don't have to pay something. There's actually a minimum of what you would have to pay, but then it goes up from there.
Awesome. Well, thanks so much, guys. This was really a hot topic. And like you said, thank you for offering a free consultation for NYPD members. Just quickly, I want to mention to the group, if you guys want to attend more seminars, be a part of a club, just reach out to me. I'll tell you how to be a part of a club. We actually starting back financial literacy classes as of next month. If you already advised me before that you want to be in part of that class, you're already on a waiting list. If not, just shoot me email, peter.kandinov@nypd.org, and I'll take care of you. Next month, we'll have a investment advisor talk about option trading. This is for guys that have experience. This is not for new guys. Again, thank you so much, guys. This was Erica, David. This was a great, great educational seminar, and I can't thank you enough.
Thank you for inviting us to speak. There's great questions from everybody, Peter included.
Thank you so much, guys, and be safe, be well, everyone, and I'll see you soon. And Erica and David, thank you again.
Thank you. Take care, everybody.
All right, guys, take care.